who recused themselves given past dealings. So I want to deal with that issue right up front and get that out of the way. I'll start with the parties first. I've never dealt with you, Ms. Beddoe. This is the first time I'm meeting, so I don't think there's any reason for me to engage in any analysis under Rule 211 with regard to disabling prejudice. So I think we're clear on that issue.
We're good, Your Honor.
Excellent. I'm glad to hear that. With regard to Mr. Bradle, Mr. Bradle and I have known each other for more than 30 years. We tried cases against each other when he was with the Suffolk County District Attorney's Office, at least a couple, probably more. I don't remember, but there were at least one significant case against each other. During the time that he was a member of the defense bar and I was a member of the defense bar, we handled cases co-defendants, although cases went to trial. We certainly had a number of cases in which we represented co-defendants, at least through the motion stage. Outside court, we had a cordial, friendly, and cooperative relationship as members of the defense bar, but we did not socialize anywhere outside a legal setting. So given our dealings, I'm certainly satisfied that I don't suffer from any disabling prejudice with regard to Mr. Bradle. With regard to Mr. Cosgrove, when he was Judge Cosgrove, I did appear in front of him a number of times. I really don't know how many times, but probably better than 25 or 30 times, I'd guess, as he sat in the various counties. I don't recall that he ever presided over trial that I did, but I know for certain that I did a number of motions to suppress and motions to dismiss with then Judge Cosgrove. There was nothing out of the ordinary in our relationship. It was purely a relationship between counsel and the judge at that time. We've never had any social contact except for in legal settings, and they're extremely minimal. Given that I took the seat that then Judge Cosgrove vacated, we were never colleagues on the Superior Court and never had any interaction on that level. And as I said earlier, we've never had any social interaction outside a few minimal contacts in legal settings. So I'm fairly comfortable in reaching the conclusion that I suffer from no disabling prejudice due to past appearances before, and certainly never did work with then Judge Cosgrove. With regard to the parties in the case, I've gone through the pleadings as much as I can. I've looked at the indictments. I've noted the names that seem to come up over and over. I'm familiar with none of these people. I've never met any of the civilians or interacted with them directly or indirectly who are involved in this case. As to members of law enforcement who are involved in the case, some of those names I have encountered, members of the state police, as well as members of the Boston police. I would add to that any dealings I had with them would have been as a criminal defense attorney, probably mostly seeking to undercut their credibility, but never had any personal dealings with them outside a courtroom. Certainly no social dealings with them. So I'm fairly comfortable in saying that I suffer from no disabling prejudice with regard to any of the parties who I've seen listed in the papers. The final issue, it is public knowledge that I grew up in Canton in the 60s and 70s and part of the 80s. I'm considerably older than all of the people involved in this case, so I didn't go to school with any of them, nor did any of the names, as I said, ring a bell for me. I lived in Canton, graduated from Canton High School in the early 80s, moved out for college, lived there intermittently through college and law school, and left there for the final time in, I want to say, 1990, to the best of my memory. May have used it as a mailing address after that as I cycled through some post-college apartments, but have not lived there full-time since the early 80s and have not lived there at all since no later than 1990. I don't have any contact with the town in particular, nor do I have a prejudice for it, for or against any issues that might happen in that town, nor special knowledge thereof. So I'm comfortable in finding that I have no disabling prejudice as to my past associations in the 60s and 70s and early 80s with the town of Canton. So that being said, I'll go around the table and see if anybody has any problem with that, beginning with the defense. Any issue at this point with regard to disabling prejudice under 211?
No, Your Honor, and I agree with everything you said, and I appreciate the comprehensive rundown of everything.
Attorney Cosgrove.
I thank Your Honor for your thorough summary. Your recollection of our personal associations exactly coincides with my own. Having listened to your explanation of your associations with Attorney Bradel and your knowledge or lack of knowledge of the witnesses that may be involved in this case, I have no objection to Your Honor sitting in this case.
Okay, excellent. All right, so obviously I'm in Brockton. You guys are at different places. I'll give you my schedule going forward. Going forward, I'm assigned to Suffolk Superior Court. The first 6 months of the year, I'll be sitting in room 1008, which is a civil session. The second 6 months of the year, I'll be in room 808, which is a criminal session. I think at least for now, we'll work this out as we go forward, have a greater clarity as to how we're going to handle it. At least for now, for the next set of motions, which we need to get to, what we'll do is we'll do those in person in Suffolk Superior Court. What room that's going to be in, I don't know yet. The way Suffolk runs things, their civil clerks don't sit on criminal matters. There are two separate clerks' offices in Suffolk. They're very distinct in what they do. So either I'll bring the matter into 808 where there is a criminal clerk, or will perhaps be specially assigned to another courtroom. Sometimes courtroom 1309 is used as overflows. I don't know where we're going to be yet, but I can tell you that the next set of hearings will be in person in Suffolk Superior Court. So let's move on down the agenda. I touched base with Judge Krupp. Certainly didn't touch base with him on the substance of the motion before him, merely as to where he stands on the motion. Judge Krupp indicates to me that a decision is not immediate on that matter, but he does expect a decision sometime. I would expect this month before he moves on to his next assignment. I'm not going to promise that, but that's what he's been able to give me in terms of a time frame right now. So, assuming, well, let me just say this. If Judge Krupp denies Attorney Cosgrove access to the Reed cell phone downloads, then we really don't have to do anything more with that. The issue is concluded. If Judge Krupp allows access to the cell phones, where does that take us next, Attorney Cosgrove?
Well, if he allows access to the cell phones, that would mean that essentially he's allowed my motion or allowed it in some modified form to set up a taint team. That means the taint team is going to have to go through the cell phones, examine. We'll have to go through a process with the Reed attorneys as to search terms and so forth that would exclude attorney-client privilege material. They're going to have to report back to the court. The court is going to then have to hear from the defense as to the findings of the taint team, and then at that point, the Commonwealth would get the information as approved by the court to go through it, and assuming that it's relevant to Mr. Kearney's case, it would then be discoverable here. I would anticipate, well, candidly, we have been waiting for the results of the taint team on Mr. Kearney's cell phone for the better part of 3 months now. So I would say that either we would enter into an agreement if the defense is amenable, or if Your Honor orders that the Commonwealth forego the evidence of the Reed search in this case. It is, after all, a motion the search warrant is, after all, directed at finding evidence of a conspiracy case, but it would likely also produce evidence that might be relevant here as well. Or we would need to delay further proceedings here. Doesn't necessarily mean do nothing, but the case would be pushed back until discovery could be delivered to the defense, and they could make such motions as they feel appropriate.
Well, let me just ask you this: as I understand it, there's already been a download of the defendant's phone in this case. Is that correct?
There's been a download of 2 phones, which is in the Commonwealth's possession and which has been turned over to the defense. And there are other electronic devices which were seized as a result of the search, and that's what is subject to the ongoing taint team here.
And there's no conspiracy charge between Reed and Kearney in this case, correct?
No.
So presumably any evidence we have with regard to Kearney is going to come off his own phone, I take it.
Well, that's the situation now. I can't speak to what might be discovered in the process of the search. The conspiracy that's alleged in the search warrant is conspiracy to intimidate a witness. The charges against Mr. Kearney here include intimidation of a witness. So it could be relevant, although obviously, no. If any conspiracy indictment resulted against Mr. Kearney, it could not be tried with the indictments here absent his consent.
Okay. So, Mr. Bradle, briefly, anything to add to that in terms of just what procedurally would have? I don't want to get into the substance of that issue. We can deal with it if we need to. But procedurally, you sort of think that's the way it would go?
Judge, we are interested in dealing with the disqualification motion first. Attorney Better filed a very comprehensive motion to disqualify Mr. Cosgrove. He's being sued by...
I'm going to come to that, Mr. Bradle.
Yeah.
I just want to make sure we understand the impact of Judge Krupp's.
Sure.
Judge, if I may, that, and I don't want to merge the motions. I understand what the court is doing, but that disqualification motion also includes the investigation involving Miss Reed's cell phones, because it is virtually the identical conduct and the identical facts that are from the 2023 indictments. And again, without merging too much of this now, there is a disqualification motion on the indictments before Your Honor now, as well as the investigation that Mr. Cosgrove is doing, because the same witness who is at issue in the disqualification was a primary or one of the primary sources that led to the warrant to go after Ms. Reed's phones. So they are kind of intertwined. And if Mr. Cosgrove is saying, as he seems to be suggesting, that he can't predict the future in the event that he were able to search the phones, but if evidence were to be discovered and lead to a conspiracy indictment against Mr. Kearney, that implicates the disqualification issue. At this time, I'm unaware that Ms. Reed has joined that motion, so I don't want to speak for what her counsel would advise, but to the extent Mr. Kearney is involved in anything to do with what we're calling the open investigation involving Miss Reed's cell phones, we think that the disqualification as it relates to Mr. Kearney needs to be dealt with in the first instance.
Well, I'll come to that. What I'm trying to figure out is if you agree with the timeline laid out by former Judge Attorney Cosgrove regarding what would happen in terms of next steps. Did that all make sense to you?
It did up until the point where...
I'll get to that part. I'm going to get to that. All right. Let's move on to the next issue. And I'll skip out of the order that I had in my agenda. The disqualification. I don't know, and I'm not going to prejudge it. It seems a little bit overbroad to disqualify Attorney Cosgrove from some other investigation. What I'm dealing with are the indictments that are before me. So to the extent that there's a motion to disqualify that's ripe, it would appear to be that it's on 23-313, not some future potential indictment. That may or may not ever come, and what Attorney Cosgrove choose to do this time outside the indictments before me, I'm going to leave to Attorney Cosgrove. But I do think we need to deal with that issue sooner rather than later, and it does not appear to me that we would have to wait for the Reed cell phone extraction before getting to that issue. Would you agree with that, Attorney Cosgrove?
Yes.
All right. So how soon would we be ready to deal with the issue of disqualification.
I
Good.
would,
Judge, I just wanted to throw out some dates if I could. January 12, 13, or 15 is what we're proposing.
Okay, does that work for you, Attorney Cosgrove?
no, I'm out of the country on all of those dates.
Okay. How does late now, Mr. Bradley? You've got some other business that's going to happen up in Essex County. You're scheduled for trial up there.
That's February 9th, Your Honor. That's correct.
And how soon before that are you going to?
Your Honor, I could, give me a moment.
Hold on, Attorney Cosgrove. Mr. Bradley, how soon before you become unavailable due to that trial?
Judge, I'm pretty flexible. I really don't want to delay the disqualification too much. I mean, unless Attorney Betterow has a different view, I'm thinking, can we do it a little sooner then?
No, I want to wait till I get to Suffolk.
Okay. Oh, I understand. Maybe is it? Should we do maybe the third week in January?
Let's see what Attorney Cosgrove has to say. What's good for you, Attorney Cosgrove?
That's fine.
Let's pick a Friday, late January.
That's the 23rd.
Attorney Cosgrove,
I can do the 23rd.
Mr. Bradley.
Yes. Thank you, Your Honor.
All right, so we're going to mark that up for January 23rd. I'll be in touch with regard to time and place. I need to talk to Suffolk to see where they can accommodate me. I'll know that certainly by early January, what courtroom we're going to be in and what time. My inclination probably would be maybe a noon or a 2 o'clock hearing. I don't expect it's not going to be non-evidentiary, I take it, correct?
Correct.
Initially, at least, yes.
That's the way I read it. So we could probably get it in the afternoon. So it'll be either noon or 2 o'clock that will deal with that matter in Suffolk on, we'll call that 123 for now.
And I think, Your Honor, if I live to see another motion after your decision on the motion to disqualify, the next logical motion to take up would be the defendant's motion to dismiss the case.
That seems to be the right step to me as well. How does that sound to the parties?
Yes, we wanted to bifurcate the disqualification from that. Absolutely.
I think that's the right choice. Okay, so do we want to get that on the calendar now, or do we want to wait till the disqualification is done?
I think it makes sense to wait, but I'm at Your Honor's disposal.
We can wait because I'm pretty flexible when I schedule things in Suffolk. Okay, we'll wait on that issue. Between now and the 23rd, are there any discovery issues that I can assist the parties with?
Yes. We have been receiving discovery. We got some, I think, that we're awaiting that was mailed out yesterday. And we continue to get discovery in drips and drabs without, as far as we can tell respectfully, any rhyme or reason. Some of the filings, Your Honor, will also see from the past several weeks. We're finding what are clearly discoverable materials from third parties, whether they be witnesses or potential witnesses in the case, whether they be other third parties who have made freedom of information requests, and they're getting actual documents that are directly related to this case. So we're just concerned about when does it end and when do we get with confidence everything. In addition to that, I believe Mr. Cosgrove, in his motion seeking extension of time in late October, whatever it was, I think it was October 24th, indicated in that motion that the former special prosecutor on the case, Mr. Mello, had discovered or come into possession of things that he believed were quote unquote relevant. We're wondering what that is and when we anticipate receiving that. And finally, with particular emphasis on one important piece of evidence that was also contained in a filing from some time ago, one of the most important witnesses in the indictments, if not the most important witness, testified in the grand jury, alleged to a series of, I believe, threatening Facebook messages and family members receiving all kinds of nasty images and comments that she claimed originated from the client or someone else, that would seem to be clearly discoverable. That would seem to be something that clearly, if not in the Commonwealth's actual possession, is, coming from their star witness, would be in their custody or control, and we haven't received that.
I don't know who you're talking about.
Jennifer McCabe.
Okay. Mr. Cosgrove?
I will look into that as to Mr. Bettero's earlier point. The materials that I have just sent him, check is literally in the mail as of yesterday, and it should be received no later than Monday, if the post office can be believed. Does include materials that I received from Mr. Bettero, notably a grand jury exhibit that they recently complained that they, I'm sorry, received from Mr. Mello, not from Mr. Bettero. Notably a grand jury exhibit that the defense complained that they had never received, that was not in my possession or in the possession of the state police. And I finally managed to get it from Mr. Mello, who had that particular exhibit. So they'll be receiving that and some other materials from Mr. Mello.
Okay. All right. Well, if there are particular issues that need to be addressed by the court, let them know. We can get together quickly Zoom and deal with them.
Judge, I think there are, and respectfully to Mr. Cosgrove, Mr. Mello seems to be the root of or a lot of these problems. And it seems to me what the Commonwealth can do is send somebody over to Mr. Mello's home or office and take custody of everything, so we don't have to rely upon Mr. Mello to discover grand jury exhibits for 2023 and 2024 being disclosed at almost Christmas time in 2025. They have the ability and resources to do it. We're entitled to this material. Waiting on Mr. Mello to provide discovery that shows up periodically doesn't seem like the best way to do it, respectfully.
Well, I'm going to leave the details of how Attorney Cosgrove complies with Rule 14 to Attorney Cosgrove. Just let it be known that he has to comply with Rule 14. If you don't, there can be sanctions. And I'll leave it at that. I'm not inclined to micromanage. I'm not going to micromanage how he complies, except to say comply. And we'll leave the details to the parties who are responsible. Okay. Let's assume the disqualification goes away. Let's assume that the motion to dismiss, the new motion to dismiss, is unsuccessful. Let's talk about the two indictments. How do the parties feel about joinder?
I think it makes perfect sense.
Mr. Bradle, Mr. Bedroff?
It's a little premature for us, Judge. We're sort of baking the cake right now, and we'd appreciate it if you let us respond to that on our next date.
Fine. I want to get started and sort of thinking about these things, because they are all the same folks, and it seems like this case, in terms of evidentiary, the acts themselves, I don't want to speak for anybody, but they don't appear to be hotly contested. It's what they are is what the issue is. One says First Amendment, the other says witness intimidation. That's sort of my sense of what the evidence is. You can tell me I'm wrong about that, but
it's a very fair characterization, Your Honor. There's a bit more to do on the newer indictment. We don't have grand jury minutes even yet, and
I understand. What I want to do is I want to push that case as quickly as I can through discovery. So if we're going to do these together, let's do them. Mr. Kearney, is that the correct pronunciation, by the way? Kearney, not Carney?
It's Carney, Your Honor.
Carney, I apologize.
Okay.
So, look, I imagine he wants to get in front of a jury of his peers and be done with this. So my goal is to move us along as quickly as we can without skipping any steps. So let's get that discovery done. Now, how long do you think, if they're joined, is this case going to take? I'm not holding you to the time, but Attorney Cosgrove, how long do you think it would take you to put your case together in front of a jury?
Well, I expect that there will be on behalf of the Commonwealth a rather extensive list of prior or subsequent bad acts that I would wish to offer in evidence, as well as the evidence of the acts for which Mr. Kearney is actually charged. And depending on how Your Honor rules on that motion, would make a fairly substantial difference to the length of the trial. I would estimate offhand, we've got 6 or 7 victims, a lot of videos to show, 2 weeks maybe.
Sound about right, Mr. Bradel?
I think so, Your Honor.
When do you folks think would be a good time to try it? I'm not going to hold you to this. I just want to start sketching out in my mind when and how we're going to do this.
Judge, on the 2-week thing, are you saying full days or half days?
I'll go full days.
Okay, that'd be fair.
Any thoughts on when we could do it? The only time let me just block this out. I'm supposed to do an asbestos trial in June. That's going to take just about a month. So June is going to be out completely for me. So, work in terms of our calendars, just sort of scratch that one off.
Judge, it's a tough call in light of how much stuff we still have to do. It's a tough call. I mean, I could see this not going until the fall, mid-fall. There's just so many. This team stuff takes forever. We haven't even gotten any automatic discovery on the second case yet. We're still waiting for a grand jury minutes. There's a lot of extraordinary motion practice here. Disqualification, dismissal for extraordinary government misconduct. Discovery, as my brother said, is dribs and drabs. We have this prosecutor who's very ill, apparently, who's no longer on the case. He's been disqualified. Attorney Cosgrove's been disqualified from the 24 indictments, which have now been dismissed. There's just so much going on in this case. It's not your garden variety situation. And I think we really are realistically, if you want to put a cap on it, I think the cap has to be, mid to late fall, because we're just not going to get all this stuff done. It's been historically glacial pace.
Just wait, I got you. And I don't have a problem with that. Mr. Cosgrove, how does that fit with your timeline and your availability?
Well, my availability is pretty open. As far as timeline goes, I don't associate myself with all of Mr. Bradel's comments. I agree with his bottom line. This is a complicated case in some respects, with quite a bit yet to do and a lot of contingencies. And obviously, if Your Honor allows the motion to disqualify me, it won't be my problem, but that will certainly have an effect on the timing of any trial as well. I will say, let
me just slow you down for 1 second. The disqualification, as I can tell, is only on the 23 case. Is that accurate?
It is accurate, Your Honor, but if you disqualify me in the 23 case, it wouldn't make any sense, as far as I'm concerned, for me to try the one incident on the 25 case. I would respectfully ask the district attorney to relieve me of that responsibility.
Well, let's not go there yet. Aspirationally, let's shoot for a late October trial date. Does that make sense? Late October, early November?
That's fine, Your Honor.
Judge, I have a couple of murder cases. I'm not sure if that's gonna get it done for me. I have a murder case, the 5th. Could we go to November, maybe November 9th, 16th, December 7th?
I can do
Any of
all,
those?
I can pretty much make those dates work, and I've checked with Suffolk, but we have flexibility here. Okay? So if that's what we're looking at, let's aim towards being ready. If it gets that far, let's aim towards being ready in mid-November.
Do you want to grab like a mid-November final pretrial, maybe Tuesday, November 17th, just throwing something out, and then maybe a trial date like Tuesday, December 1st?
Pencil it in your own calendars for that time. I'm not going to set the date yet because I need to confer with the clerk in 808. I don't have access to that docket right now, but pencil yourself in for around that time, and we'll put this up once we get through the motion to disqualify, which will be on the 23rd. Okay, so, but let's try to work our way towards that date, and get this thing in front of a jury, and get it resolved, one way or the other. Okay. What else can we do?
Good, Your Honor. Thank you. I think that's everything on your agenda, Your Honor. I was following along on your scheduling order.
Mr. Cosgrove, anything else?
I just have one minor issue that I'd like to raise. It's not a big one. For some reason, Your Honor, Judge Doolin entered an order that all filings in this case were to be paper copies. I'm not sure why he entered that order, but I do find sometimes that when we are close to a deadline, I am close to a deadline, that taking a special run over to Norfolk Superior Court to deliver a paper copy is a lot less convenient than being able to do it electronically.
I would read Judge Doolin's order to be a paper copy has to be filed. If you're up against a deadline and you have to email it in so we have it to prepare, that's fine, but a paper copy is going to have to be put in the file at some point. But if there's a deadline set,
if that's Your Honor's interpretation, I can certainly comply with that.
Attorney Braden, Attorney Betterow, and I have it.
That'd be a big help. I agree with it, Your Honor. Thank you.
But make sure a paper copy gets filed so that it, I'm not even sure that, Mr. Braden, you can correct me because it's been a while since I sat in a criminal session in Suffolk. I don't think the Suffolk Clerk's Office takes electronic filings, do they?
No, they don't, Your Honor. Norfolk does, Suffolk doesn't.
All right. So right now this is a Norfolk docket. So you're going to continue to file there, but if you file electronically to the parties circulating the documents that way, that's fine.
Appreciate it. Thank you.
If it's a day late, it's a day late. You don't need to drive to Norfolk to get the paper filed that day. As long as it's electronically filed, followed by a paper file, that's fine.
Thank you, Your Honor.
All right. Anything else we can do today?
Not for the Commonwealth. Thank you very much, Your Honor, for your time.
So let me ask you one more question before we go. Are all the papers that I need for the disqualification motion filed?
No, Your Honor. Just a couple of hours ago, Mr. Cosgrove, I think, filed a response that, frankly, we had anticipated earlier, but we filed something addressing that yesterday, which I don't know if the court has seen or not. And Mr. Cosgrove filed something today. We've perused it. I believe I'm going to want to file just a brief reply in the next 10 days or so.
Brief reply. We have lots of.
I'll do my best.
Lots of paper already in this.
I may have an additional filing as well, but it'll be well within the 10 days that Mr. Betterow speaks of.
I know that the civil rules have already been brought into play here in the pleadings here, that they don't apply, but there is that motion reply, sir reply, and that's it. You can file what you need to file, but
yes,
it just doesn't. It's got to end at some point. All right. So file what you need to file. I want everything filed 10 days prior to the hearing. Okay. So no filings will be accepted on the disqualification issue unless there's new evidence after 113. Let's get this thing squared up and ready to be decided that day. Or argued that day, decided shortly thereafter.
Yes.
All right. Anything else we can do?
It's good, Your Honor. Thank you.
All right. I'll as soon as I get to Suffolk and I have a better idea where we're going to sit, I will give you folks notice as to the time and the actual time of the hearing and the courtroom in which we'll be. That'll be an in-person hearing.
Thank you, Your Honor.
Thank you.
Mr. Better, do you intend to be there in person?
I will. Yes.
Excellent. Because Zoom is a little difficult when some people are hybrids are difficult. Let's put it
Yes.
that way. Okay. That's all we have today. Thank you very much. Margaret, you can close it up.
Thank you.
Thank you, Your Honor.
Thank you.
All right, folks. My name is Grant Smith Ellis. You heard it. I'll recap it. We'll watch the replay. Then we'll take it home, and then you'll see me live again at 7 o'clock, where I'll be talking with Social Change Warrior, and we'll digest those happenings, filings. There's a lot to talk about. All right, so my name is Grant Smith Ellis. Where are we going to begin? Let's begin by talking about what just happened. So we have a trial date in the Aiden TurtleBoy Kearney case. All right, I repeat, we have a trial date, ladies and gentlemen. That trial date is mid-February, ladies and gentlemen, mid-November of 2026, which is exactly after the Norfolk DA's election. Now anticipate a few delays on that trial date into January of 2027. The new DA's in office. You can see Bradel and Betterow got exactly what they wanted. They weren't exactly jumping up and down to say it, but it was very clear, ladies and gentlemen, that the Kearney defense was very pleased with that initial setting of the trial date. It's because it's provisional, and the new DA will no doubt already have been selected by virtue of the primary and the general election. The primaries in August or September of 2026, the generals in November. So first Thursday or so. So there you go, folks. That was the big moment. I mean, it's a little bit hard to see it. You really had to have been watching it. But it was there. It was a big deal. I'll take you through it. And I'll tell you, I think the state is on the ropes. Did you hear Cosgrove say that if he is disqualified from the 2023 cases, they're just going to abandon the 2025 cases? My goodness. My goodness. And we didn't even get to touch on the actual discovery disputes. Not to mention the other big news, all future TurtleBoy cases will, going forward until probably trial, will be at Suffolk Superior Court in Boston, because the judge in this case is sitting there, so he's not going to drive down to Dedham. Judge is going to be assigned in Suffolk. He's specially assigned to this case. That's what they did. The justice system took this case out of Norfolk County. They didn't, I guess they... And then by specially assigning it to Judge Belzeos, by then putting Judge Belzeos in Suffolk County, they were able to just say, well, why don't you have the hearings in Suffolk? It's a completely different atmosphere. Parking is incredibly expensive. It's difficult to get to. You can stand outside in the plaza, but it's like right in front of the SJC. Yes, it's more accessible for the media, so that's probably a positive for TurtleBoy, but it's a different environment. It's not like you stand outside, walk in through security, and you're in the courthouse. If you've never been to this area downtown, I mean, I can show you it on Google Maps. If you want to see the courthouse that Kearney's going to be in, let me just tell you right now, this is no regular district court. I don't know if a lot of the Turtle Riders have been down here before. Let me just pull up the Google Maps, and of course, I'll show it to you for the purposes of us being able to learn. So let me just show you what this is like, okay? I'm going to see if I can get the street view, no promises. So just the location of it, I mean, it is literally in the middle of downtown Boston, all right? Now, I don't know if we're going to be able to actually get a shot of it. Maybe they let you zoom in, hold on. So let me just show you what this building is like, okay? Let me bring this up on the screen for you, 1 second. Oh, no. I closed the chat. I brought the chat back. All right, let me just show you what this is like. So this is the biggest news. I mean, this changes everything. I don't think anyone was expecting this. So take a look at this right here, okay? Take a look at where the building is located, all right? So it's right there. Just to scroll out here if you've never been to Boston. So that's coming over from Cambridge. It's going to take a while to load. That's coming over from Cambridge. That's coming from like BU and the Fenway area over here. That's the Common, all right? That's the middle of downtown. That's the State House. And then that's like literally like where City Hall is. And then if you zoom in, this is the building right here. Is that it? Did I lose it? Yeah, I lost it. It's this right here. So you have to go, there isn't any parking. There is some parking if you know the area. There are some places you can park, but there is not very much parking.